Well, good afternoon, everybody. I'm David Tingstad, Chair of the Business and Real Estate Group here at Beresford Booth. I'm here with my colleague, Per Oscarsson, and we're going to talk about some pretty fundamental stuff today about transferring real estate by way of deed. But it's our experience that people don't always know or understand about the fundamentals of deeds, as there really is nothing more fundamental in a real estate transaction than a deed. Mr. Oscarsson and I have done, I don't know how many different transactions together over the years, and we do spend a lot of time looking at deeds, and there is no one finer than Per when it comes to legal descriptions and dealing with title objections and all kinds of fun things like that. So that's why Per's here. He's here to do the heavy lifting on a lot of these things, but we'll have a little fun in our conversation today. And so Per, if you're ready, I'm going to turn on the PowerPoint. And feel free to hit me with questions, comments, concerns, because I'm going to do the same thing for you. So
okay.
All right, if we're ready, we'll go here. And with any luck, I have started sharing my screen. Per, can you see my screen there?
I can.
Nice. All right. Well, so we're going to talk about some deed requirements and covenants. And exactly what those are. And so I'm going to just talk about for a minute generally some requirements of deeds. Now, these are statutory requirements largely that have been around for literally hundreds of years. And this part isn't really news, but we do see people who try to transfer title using something other than deeds, whether they're doing it by way of LLCs or other things. But you have to do it in the form of a deed. The deed has to have certain forms. It has to identify who is transferring and who is receiving. We call that the grantor and the grantee. We have to identify what it is that is being conveyed, what it is that's being transferred. For example, you could be transferring what we call fee simple, which is everything that you own. It could be just a life estate or something less than everything that you own. Could be retaining some sort of interest in the property. And it's important in the deed to call that out exactly what you're transferring.
Could even be an easement, like a driveway, an access or utilities easement.
That's exactly right. In fact, because Per, I'm glad you brought that up, because the easements are real estate and they have to be transferred in the form of a deed. And so they can be created in other ways. They can be created on the phases of short plats and things like this. But if your easements can be reserved and all kinds of things like that, but have to be used by way of a deed. And what you're transferring, Per, is exactly right. If you're transferring an easement, do it by way of a deed. And then you need to talk about consideration, and you see this a lot. I mean, exactly what the consideration is always interesting. Could be love and affection if it's a gift, parent to a child. Could be, you see this a lot, $10 and other good and valuable consideration. Now, just because you're saying $10 and other good and valuable consideration, it could be for literally millions of dollars. That may be what is exchanging hands, but you still have to recite what it is. And here's a big one, legal description. We just had Ryan Dyer and I just had a case up at the Court of Appeals that came back this week, a reported opinion about exactly what needs to be in a legal description and how one makes that valid transfer and what's in that legal description. I mentioned a moment ago that Per is great when it comes to legal descriptions and trying to make sure that they actually close. And you would be amazed the number of improper legal descriptions are out there. Per, I wonder if you might mention maybe some of the challenges that you've run into when looking at legal descriptions. Maybe just an example or two.
Well, a couple of them. One, and we just saw yesterday, it identified a lot, but it didn't say where the lot was or what it was in. So, for example, there was no subdivision indicated. And it turns out it was probably a government lot, which when they did the original surveying of these township sections and ranges, which was a government survey done many, many years ago, they're generally six miles by 6 miles, but there are some sections where a lot may not fit that kind of parameter with, nice north, south, and east-west boundary lines. For example, you might end up with property that's near the water. It's going to have probably a very irregular shape. Maybe 3 of the boundaries are nice straight lines on land, but the shoreline is not. And so you end up with a government lot. And sometimes that's how property is still conveyed, because it was never platted for anything. Sometimes you'll have what's called meets and bounds descriptions, which those can really be interesting, because if they're just taking the degrees, minutes, and seconds of a compass and say you start at this point, you clearly identify that first point, and then you say you're going to go north 45 degrees west a certain number of feet, and that'll get down to hundredths of a foot, and then you're going to go this direction for so many feet, and then this direction for so many feet, and hopefully when they're done, they get back to the starting point. But I have also seen where you go to the 15-inch diameter pine tree at this point, and now you're looking at a legal description that was done in 1940, and either the pine tree has grown dramatically or it no longer exists. I've also seen where there's a reference to, you go to the corner of the property that was conveyed by a prior deed to so-and-so. Well, that prior deed may have been, 5, 10 deeds back. So you end up with quite a variety of legal descriptions. You can have a very nice short but full legal description where it's lot 1 of block 1 of such and such a subdivision recorded in the county under this recording number. That's great. But I have also seen these meets and bounds descriptions that go on for about 4 pages, and trying to follow them, hopefully you've got a survey that allows you to do that. But with any luck, you've got a nice, clear lot 1, block 1 type of description.
Yeah, I think that's really well said. And a lot of times, we blow right past the legal description. It's included in a title report or something like that, and we just assume. And you cannot do that. Legal descriptions it's what you're getting. And the other part about legal description, Per, and you and I ought to talk maybe a little bit about this, is not only are we talking about the legal description in terms of the property to be conveyed, but then in addition, we're also talking about what is accepted from that title.
That's right.
And so oftentimes you'll see we're transferring, we're conveying all right, title, and interest to a certain piece of property. Then it's legally described, except all matters of record, including, and then it lists a whole bunch of easements and other encumbrances, and it's really important to call those things out about what is not or what is accepted from title. And those lists can be quite long if you have a piece of property that has been around a long time and may have a bunch of things like, I don't know, pair utility easements and things of that nature. What kinds of things do you see that are being accepted from title or accepted from that legal description?
Sometimes you get like a nice rectangular piece of property, but maybe the east 15 feet or the east 50 feet have been accepted for some reason. Usually they've become a part of another piece of property or another lot, but a lot of utility easements, for example, I think that's primarily what I see is easements that are affected. And you're right. It's really important to specify, whether you specify each particular easement or you make the general statement excluding or accepting therefrom all easements of record, or what you would find in the survey or what you would find by looking at the property, because the statute, and we'll get into this in a minute, the statute that deals with deeds, or the statutes that deal with deeds, say you're conveying this free of all encumbrances. Well, you just use that language and you just find out there's 15 easements on this piece of property.
That's right.
I just blew it completely.
That's right.
So I have seen where people have just taken, when you get a preliminary title commitment, for example, that has all those exceptions to title, the easements and taxes and that kind of thing, that I have seen those taken from preliminary title commitments and attached to the deed where it says, accept those things on attached exhibit A.
Right.
So you get a lot of detail, but I've also seen accept the general statement, covenants, conditions, restrictions, requirements of record, which would cover all those same things because those things are of record because the title company found them.
That's right.
So I've seen it both ways.
Yep. So I think that's exactly right. I'll get back to my screen here so we can keep going through our list. So that legal description, I wanted to take a little bit extra time to talk about that because it's a major one, and there's a lot of things that go into that. So in fact, we could probably do a whole webinar just talking about legal description, but this is we're supposed to be primarily talking about covenants of title, which we're going to get to here in just a second. So again, requirements of a deed's got to be in writing. We got to know who it's going from, who it's going to, what is being conveyed, what the consideration for the transfer, what is being transferred in terms of the legal description of the property, has to be signed by the party that is transferring the property. And it also needs to be acknowledged and that has to do with recording. And so that means it's got to be in front of a notary, and there are certain requirements for what an acknowledgement needs to look like. So if you have all of those things in writing, and everything is nice and neat, and you've looked at the legal description, that's great. You're still not done. And it used to be back in the really old days, that what you would do, right, is you would take a deed and actually hand it to somebody. That was what we called delivery, because you have to, you just filling out the deed, that in and of itself doesn't transfer the property. You have to deliver that deed to the person to whom you're transferring. And it's really interesting how things have developed over the years, because now you hardly ever see that occurring. Because what happens is there's an escrow company that has the deed, and you deliver that deed to the escrow company, and then there are some other things that happen in terms of transfer of money, and a bank might be involved in things of that nature. And there never is a point in time when the seller hands to the buyer the deed, and yet somehow magically all of these transfers happen, and that's because recording is deemed to be delivery. It's good enough is what the law holds today.
But I think that's also it's a presumption of delivery, but it's also rebuttable. It's a rebuttal.
You're right.
Because a grantee could say, "Hey, I never saw anything."
That's right. Yeah, definitely. And so when you think about that, I mean, for example, if you're transferring property into a trust or into an LLC where there's no escrow involved, and maybe the trustee is different than the grantee, did delivery of that deed ever actually happen? I mean, it's an issue. So the point simply being, I don't want to belabor the point, because there are a lot of cases, and you spend a lot of time in law school talking about things like delivery, but nevertheless, it's a requirement for a valid transfer of property, or for a valid deed to occur. So now I'd like to change the conversation to things. I mean, most of us know about these requirements, but there are other requirements, if I can turn the page here, that are things that are actually happening when you deliver a deed, when you comply with all of those requirements we just talked about. Things that are actually happening that you may not know are happening, with things we call covenants of title. So Per, I'd love to turn the conversation over to you and let you talk about these sort of odd sounding things like season.
Yeah, there's one that goes back several hundred years. That one is, it goes back to feudal times. And it's basically that you are saying that you own the property, you have possession of it. You may not technically have possession because maybe you're leasing it out to someone, but you own the property. And then the right to convey, that there's nothing that prevents you, no agreement, for example, or nothing in the deed by which you received the property that prevents you from transferring the property.
So, hey, Per.
Yeah.
I've seen a lot of deeds. I have never, ever, I don't think, seen the word like season or somebody saying, I hereby represent and warrant that I have the right to convey this in the deed. Have I been doing it wrong all these years?
No, the statute is that deals with each of the types of deeds that we'll talk about, gives you kind of the form of the language that you need to include. But the statute then also says, in each case, there are these certain covenants that are made depending upon the type of deed you're using, and those covenants apply whether or not you say them in the deed. And I don't remember seeing too many deeds over the years that specifically say, I'm warranting, as you just said, I'm warranting all of these things to you as my grantee. And the grantors may not understand that they are warranting those same things.
Exactly.
I'm not so sure how often the issue really comes up that, oh, you really did breach that warranty when you conveyed the title. Wait a second, I conveyed that title 20 years ago. Well, yeah, you breached it at that time. Now, maybe there was no damage as a result of that, depending upon which covenant it was that you allegedly breached. I think it's the next one that we see, the encumbrances. I think that's the one that probably causes the most problem, because of the fact that without any special exception language that we talked about, you're warranting that there are no encumbrances against that property. And that I think is a dangerous thing, because I think there are very few properties that have no encumbrances of some sort against them. And they may be minor, you know, there may be the east 2 feet are used for utility easement, but the property is 2.5 acres. That's not a big encumbrance, and it's not one that you would find unusual,
right?
But it's there. Quiet enjoyment, that once the property has been transferred to the grantee, that they will have the right to possess that property. And if it's something that arises later on, where some third party is saying you don't have the right, then as the grantor, I may have the obligation to defend, and probably do have the obligation to defend my grantee, to say, yes, you do have the right, but I'm going to have to pay for establishing that, if that issue has come up.
That's a big one. I agree. That's where a lot of people don't realize what they're signing up for when they give a statutory warranty deed, that none of those words are in there, but nevertheless, they're promising that. And in fact, there are more covenants of title. Per, I think there are a few more.
A couple more.
Turn the page there. Go ahead.
And that's kind of part of number 4 as well, that there may be some other one of those warranties that you may have to defend later on because something has arisen, although neither party may have even anticipated that was going to be an issue. I've seen this in one of the things we'll talk about in one of the forms of deeds with real estate contracts. The way that they work, the real estate contract is normally something that many years ago was used to convey property, but it was a contract that provided for payments over 30 years or 25 years.
Yep.
And the grantee, the purchaser in that case, does not receive title to the land until they've paid the contract. Well, sometimes what happened, and in the best of all worlds would have happened, is when they signed the contract, the seller also signed a deed. And that deed got put into escrow. And then when the contract was paid in full, escrow was supposed to record the deed. Well, sometimes that deed is either lost because the escrow company has gone out of business, or was never done in the first place. And now maybe there have been some transfers of title, and I'm running into that with a couple of things that I have going on right now, where the grantor now doesn't have title because there was never a fulfillment deed done, maybe on a prior owner. And then the further assurance is also one of those things where, you know, there may be some other things that the grantor might need to do, and they're agreeing to do if it's necessary to perfect the title, to make sure that the title is now in the grantee.
Well, you used a magic word there, Perry. You used I think you said fulfillment deed, and so what that throws us into then is our final slide, where there are different types of deeds, and so the reason that we talked about the covenants that go into title first is because depending on the kind of deed you use, that impacts the covenants that you are actually making. So, for example, a statutory warranty deed, which is in residential transactions, is probably, what would you say, Per? 75, 85% of transfers of residential property is happening by statutory warranty deed.
I would think it might be even higher than that, because you know, some of the forms, the purchase and sale forms that are used, they specifically state statutory warranty deed is what's going to be used to transfer title, which is not a surprise because it does have the full covenants. It is possible with a purchase and sale agreement to agree to take some other form of deed, but most buyers will want to have the statutory warranty deed, even though they're also most likely going to be getting title insurance that says, yes, this grantor does have the ability to transfer title to you, and this is what your title will look like.
Yeah, no, that's exactly right. But a lot of people won't realize that when they sold their house, that they made all those 6 covenants, and their obligations continue.
Right.
So it's definitely something to keep an eye out for. And so, the first 3 of the deeds that are listed here, statutory warranty, bargain and sale, and quitclaim, are all talked about by way of our by the revised codes of Washington statutes. Legislature's passed acts about this. And so the bargain and sale deed only contains 2 of the covenants, unlike the statutory warranty deed, which includes all 6. And then the quitclaim deed that has no covenants at all that go to it. So when you accept a quitclaim deed, for example, parallel, you know, we talked about this in law school, obviously, is I could give you a quitclaim deed to the Brooklyn Bridge. And that would have the effect of transferring all of the interest in the Brooklyn Bridge that I own. And by doing that, even though I own no interest in the Brooklyn Bridge whatsoever, I haven't breached any warranty because I haven't made any warranty to you. I haven't even told you that I own it or anything. Just whatever I have, that's what I'm getting.
Right.
And there are a lot of deeds that are done that way, a lot of transfers into trusts or LLCs, that kind of thing. Estate planning purposes are done that way. And there are some consequences associated with using quitclaim deeds. Certainly for receiving one, if you were buying a house, you probably would not want to accept a quitclaim deed because you would want a few more representations and covenants standing behind that.
Right.
So Per, maybe you want to, we're running short on time here. Do you want to just maybe mention the last 3 deeds here before we wrap up?
Sure. Yeah, one other thing on the bargain and sale deed, the encumbrances that you're saying it's free of, it's really free of those that you may have created. Whereas with the statutory warranty deed, anything you even created before you ever owned it is going to be subject to that warranty.
That's a great
point. So on the condominium deed, you know, condominium is a little bit different than just a house in that with the condominium, you're buying your particular unit, but you're also getting some kind of a percentage interest in common elements. And so, again, it goes primarily to the legal description on that one, that not only the description of the unit, and that may even include reference to the survey map and the plans in the legal description, but also to those common elements. Special warranty deed it's very similar and I think most of the language is the same as a bargain and sale deed, but you'll see that with personal representatives in an estate, we'll usually use the special warranty deed. I think in Washington, there is no statute that talks about the special warranty deed. In other states, what we call a bargain and sale deed, they would call a special warranty deed. And it makes a great deal of sense, particularly if the personal representative was not a co-owner of the property. For example, it could be a family member, but a family member may not know a lot of those things that would be covered by a full statutory warranty deed, but they're willing to provide the bargain and sale deed because they're saying, well, I didn't create any encumbrances and I don't know a lot of the detail of what happened with this property before. The fulfillment deed that goes back on the real estate contract, those are a little unusual because they don't really specify the grantee most times. They say we're conveying title, it's the trustee of the deed of trust, or I'm sorry, I shouldn't say deed of trust, but the grantor is in conveying property to whoever's entitled. And that may or may not be the original purchaser. And the seller hopefully would know who now is entitled, but they wouldn't necessarily know, because it is possible for a purchaser to assign their rights under the contract. So we see those, but we also see a bunch of problems on occasion when those haven't been recorded, and unfortunately may not exist.
No, that's exactly right. Well, there certainly are a lot of things that go into deeds. Just by way of summary, we talked about on the first slide the importance of having a writing, legal descriptions, grantor, grantee, and acknowledgement, delivery. A whole bunch of requirements necessary that are formal requirements necessary to transfer property. Most of those are known by folks. What a lot of people don't know, though, is that there are a bunch of other covenants that are typically involved in a deed, even though those covenants are never stated on a deed. And it's one of the things that Per and I spend a lot of time looking at and making sure whether our client is receiving the necessary covenants or the legal descriptions are accurate. All the formalities have been followed. It's part of our process of dotting the I's and crossing the T's. But Per and I would love to help you anytime, any transaction that you're working on. Like I say, there's a lot that goes into it. So certainly would encourage you to give us a call if we could be helpful. Per, I'll give you the last word here before we sign off.
Well, I'll take the Sergeant Esterhaus statement. Let's be careful out there, because those deeds can have a significant consequence.
That's right. Well, I love it.
Positive or negative.
Yeah, very well said. So I just want to thank everybody for tuning in. I'm not exactly sure what our topic is for the next webinar next Thursday, but I know it will be fascinating. And so this is Dave Tingstad and Per Oscarsson saying, let's be careful out there.